do I have here in the courtroom?
Thank you, Your Honor. James Fontano, bar number 8456, on behalf of defendant Capucine Holmes.
Okay. Who do I have on the phone?
Good morning, Your Honor. This is Wilbert Holmes.
Okay. All right. So what we've got on calendar today, I have two matters. First, I have Ms. Holmes' motion to dismiss the complaint. And then I've got the plaintiff's motion for judgment by default. First, let's talk about the motion to dismiss. So, counsel, as you know, it's a fairly low pleading standard, so tell me why this fails to meet that standard for pleading a claim for relief.
Thank you, Your Honor. In order to successfully plead a claim for intentional infliction of emotional distress, the plaintiff has to at least lay out some action on the part of the defendant that would rise to, let's say, extreme and outrageous conduct with either the intention of or reckless disregard for causing emotional distress. Mr. Holmes, in his complaint, laid out various allegations all pertaining to a red dress affair that his ex-wife was at. Mr. Holmes arrived. He did not have a ticket. The event was sold out. He was told by the organizers.
Okay, that's facts that I don't have in the complaint, right? Does the complaint say it was sold out and he didn't have a ticket?
I apologize, Your Honor. I don't have the complaint with me.
Okay.
But he made the allegations that he came and that he was not admitted.
Right.
Okay. Not being admitted to a social event does not constitute, does not rise to that level of extreme and outrageous conduct with either intention of or reckless disregard for causing emotional distress. That's the allegation he's raised against my client. Not even that she didn't allow him in, but that she had somehow conspired to keep him out.
Right.
Your Honor, it's my position, it's our position that conduct, the conduct that is alleged against my client, does not rise to the level as required under the Starr versus the Bello case, and that under Madueke versus Agency Rent-A-Car, he has not pled a claim against Ms. Holmes that rises to the level of intentional infliction for emotional distress.
All right. Right. So, yes, so he alleges that she, yes, conspired with others to keep him from being admitted, that there were some contrived reasons, that he stayed and socialized with people for a while. And then, you know, they had called the police, and the police came and escorted him out and took his cane. And I mean, there's some other incidents that are alluded to in the complaint as well. And then there's multiple addenda to the complaint. I don't know if you have seen those as well, too.
I've seen a number of addenda that purport to be press releases that I believe are just authored by Mr. Holmes.
Right. Okay.
But again, Your Honor, those things that he's alleged, they were actions taken by other persons, not allowing him into the affair, and calling the police, and then the police taking his cane. So they're actions by third parties, not by formerly Mrs. Holmes, Ms. Holmes, and they're not actions that rise to that extreme level of behavior that is contemplated by the Nevada Supreme Court. So I think on both fronts, there hasn't been a claim alleged against my client that constitutes intentional infliction of emotional distress.
Okay, and just so we're all clear, you represent only Ms. Holmes.
That's correct, Your Honor.
Right, and so that's the only party that you're filing this motion to dismiss on behalf of?
That is correct, Your Honor.
Okay. All right. So, Mr. Holmes, what we have is a motion to dismiss on behalf of Ms. Holmes, who's represented by this attorney. So, as you've heard, he's arguing that what you've alleged doesn't state a claim for intentional infliction of emotional distress. So how do you respond to that, sir?
Well, those statements are really off base, obvious. What I'm saying is very factual. I can document all of the statements that I made in my complaint. It's factual. When I entered that affair, myself and a friend, I had no knowledge of not being admitted. And their reason for not being admitted is fallacious. I've been attending that affair every year since I've been in Las Vegas. I was even on the committee of that affair and did DJ work on that affair. This particular night, I was really trailed by the security of the facility. And I asked them, what's the problem? And they didn't say anything. And when I entered the door, they had their board of directors committee, a lot of people surrounding me and my friend, very insultingly telling me I could not come in. And that was shocking. It was outrageously shocking. And I wanted to know why. And they told me I didn't have a ticket. People were entering that affair before and after me without a physical ticket. They were making donations at the door that have been done, that have been every year since I know about it. And that's over 15 years. They make donations if they don't have a physical ticket. And my friend and I were prepared to make donations like the people in front of me and behind me that entered. But they had me surrounded and with these insultingly words, and they had no premise to keep me out. The security had no premise to not admit me, and they saw that. And I entered and I socialized with friends and relatives that I have been knowing here since I've been in Las Vegas. I was paying no attention to anything else. I wasn't aware until I really got in the place and viewed her sitting with one of her mates, her numerous mates, I might add. And I was told by other acquaintances that she had jumped under the table, putting on an act like I was coming to harm her or her table of friends, which was ridiculous. I haven't had a criminal record in my life ever assaulting anybody. 71 years old, I pride my clean record. Well, there's no record. You can't say a clean record if you don't have a record. I don't have a record until these divorce situations come up. She had verbally told people that I was coming there to kill her and her mate. I've got facts and witnesses to say that. And once I found that out, it was devastating. It's still devastating what happened. And I had to go see doctors to keep my actions in order. And there's a clear record of the doctors that I've been seeing since this occurrence. And I found out about this rule, the law, the tort, and I filed a complaint. Because if anybody should fit into that rule, the tort, it would be me. It was outrageous what they did to me. People I've been doing for years. She convinced them with her convincible charm that I was trying to come there to hurt her, and obviously I wasn't. If it's anything, it was the other way around, because her mates carries a CCW everywhere he goes. He's threatened me on another occasions. Came to a court hearing and physically got out of his seat to attack me, and I had to dodge him on my cane. There's numerous situations that I've had to face by saying I do to her. which was the worst decision in my life. So Your Honor, I can document every claim that I've submitted before and after. The doctors have told me to stay away from court settings, and that's what I have to do because I can't function in a courtroom setting. I physically pass out. It's just too much mental. I'm on a lot of medications now, medications now to live. I have a brain tumor, and I'm not crying on your shoulder, and my days are numbered. The doctors attest to that.
And you're alleging that this effect on your health is because of the events of being kept out of this red dress affair?
That's a big part of it, yes. I mean, if you put yourself in my shoes, anybody, it's a slap in the face with a sledgehammer. I think I handled myself very well by leaving the way I did, and I was fussing and I was cussing, and yeah, I was upset, but I didn't physically touch anybody. Matter of fact, one of the people named in the lawsuit, 2 of them attacked me after her verses and words to them that I was coming there to kill her. I didn't know any of this till I got there. One person, Mr. Tommy Kason, physically blindsided me with a swing and knocked my cell phone out of my hand, cursing, telling me don't take pictures. The other person, Lawrence Lee, who I've been known since high school, was one of my best high school friends. He was attached to them through another girlfriend of hers. So he was on that at that table too, and he stood up and confronted me. I'll kick your ass. That was shocking. Somebody been knowing all your life, all of a sudden he wants to do you bodily harm. I wasn't there to do anybody bodily harm. I was there to entertain me like it's been doing for 15 years. And Your Honor, yes, I've been seeing doctors. I got an appointment tomorrow to keep my mind together outside of my physical problem of having a brain tumor. This is only one, the main incident in a series of situations with Capucine, and I don't like to use her last name because it's my name. It's awful. I wrote a documentary about things that has happened to me because of her. Yes, I've submitted a lot of paperwork, and of course it reads like a novel and a soap opera, but it's all true. I can document everything that's there behind her actions towards me. I've been incarcerated.
Thank you, sir. Sir?
Yes, sir.
Thank you.
Yes, ma'am.
Okay. Rebuttal.
Your Honor, I just point out everything Mr. Holmes said. A lot of those things are not included in the complaint, but what he basically admitted to is he got there, Capucine was hiding for fear of her life, and other people, third parties, escorted him from the premises.
She's a good actress.
Facility security.
Please stop. You had your turn.
Sorry.
Facility security and the Henderson Police Department. So these are not just random people that are escorting him from the location. However, they are third parties. They are not my client. I would also point out that as a matter of public record, Mr. Holmes has made a pretty serious misrepresentation to the court here. He was convicted in November for assault with a deadly weapon against my client on his plea. He pled out to that, Your Honor. And so to sit here and represent to the court that he does not have any kind of a record is an absolute misstatement. And fraudulent misstatement to the court of his circumstances. He has physically assaulted my client. He's having a hard time in just accepting the fact that they're divorced and this is over. Right. But as it pertains to this case, Your Honor, he has not alleged anything in the complaint against my client that rises to the level of an intentional infliction of emotional distress.
So,
May I have a
taken in
rebuttal?
What's that?
May I have a rebuttal, Your Honor?
Very briefly, sir.
It's not true what he says. I've never physically touched that woman ever. And if I did, I would have had a domestic violence situation. She has two for attacking me. She has two domestic violence convictions and sentences. I have none. The only record that occurred was behind the divorce situation where they got an unauthorized, or I'll say undue TPO order against me for a Facebook post. There was no weapon involved whatsoever. I got sentenced by being represented bad by the defender. It went from a plea. She convinced me to plead to another charge to stay away from any kind of jail. And that's what I was talked into doing. And by my shocking surprise, I was charged with assault with a deadly weapon. I physically never had a weapon in my hand. It all stemmed from a Facebook post and social media. That's where this charge came from, and I was basically railroaded, unrepresented in that whole matter, which I am appealing. I never touched her.
Okay. All right, thank you. So I do find that the allegations in the complaint taken in the best possible light allege that Ms. Holmes was involved in not just keeping him from being admitted to this particular event, but that there were misrepresentations to others, that he was threatening them or going to hurt them, and that while it was the Henderson police that ended up removing him, but that she was behind that and told lies about him to make that happen in front of his friends and acquaintances. And I think under the very lenient pleading standard under Nevada law, that states a claim for intentional infliction of emotional distress. Obviously, at the end of the day, whether it's proven is a different story, but I, you know, if the facts end up showing that he was removed because he didn't have a ticket and it was a sold-out event, obviously that would be a different circumstance. But on a motion to dismiss, I'm just looking at the face of the pleading, and on the face of the pleading, it says enough to state a claim. So I'm going to deny the motion to dismiss. Now, Mr. Holmes also filed a motion for judgment by default. I have found in the file that a default was entered against defendant Ernest Miller on May 30, 2018. I haven't seen a default filed against any of the other defendants. So you can't get a default judgment against the party unless you've already gotten the default first. Mr. Holmes, have you obtained a default against any of the other defendants?
All of my filings, Your Honor, most of them, as I was informed by the center down the Telpilk, was ETTAL, E-T-T-A-L, and that represented all of the defendants, Ernest Miller ETTAL, because they were all, as I understand, defendants in the complaint.
They are all defendants, but the default that was filed on May 30th just names Ernest H. Miller as the defendant that the default is entered against. I'm going to take a quick look at the case here and see if there's something else that I've missed.
Excuse me, I didn't put E-T-T-A-L on that?
I don't know, sir. Yeah, well, no, it's not on the default itself, which was filed on May 30th. And you would need to when you're entering a default against a party, you need to identify the parties that your default is against. Let me just take a quick look here for anything else. Default. Right, the default itself, which is the default is filed May 30th and it names Ernest Miller. Let me take a look at what else we got here. Oh, I see. So, yeah, you filed a request seeking default against multiple parties, but the only party named on the default itself is Ernest Miller. So you have a default against him. If there are other defendants who you've served and have not timely responded, you can get a default entered against them. And then in order to seek your default judgment, you'll need to submit an application for a default judgment that includes the documentation and other evidence to support the amount of the judgment that you're specifically seeking against them. So I see in the motion you filed for judgment by default, you're seeking judgment against Ernest Miller for $300,000 and costs of $5,000 for a total of $305,000. You need to submit evidence to support those damages that you're seeking, which can include an affidavit from yourself, documentation of any costs you've incurred, for example, whatever it is that you're seeking that you say gives rise to the damages that you're seeking to recover. You're going to have to submit all of that to get a default judgment. And for a judgment of $300,000, I'm also going to need what's called a prove-up hearing, where I actually need to swear you in as a witness to testify about the damages that you're seeking to include in the default judgment. So you need, if you're seeking, so I'm not going to enter a default judgment today because it's not properly supported. You may want to go ahead and proceed to get defaults entered against the other parties who have been served and not appeared, which would not include Ms. Holmes because she's obviously been represented here in court. You can get defaults against them and then proceed to seek a default judgment that's properly supported, and then you come in for a prove-up hearing where you'll be sworn in and testify about your damages, and I can determine what amount to award as damages at that time. Okay? Mr. Holmes, do you understand that?
Yes, Your Honor.
Okay. So I'm denying without prejudice the motion for judgment by default today, and that's the way that you should proceed to go ahead and obtain a default judgment. Now, as to Ms. Holmes and if any other defendants appear, you need to, well, now that I've denied the motion to dismiss, you'll need to go ahead and file an answer, and then the parties will need to have a case conference and get a discovery order in place, and that's the way the case will proceed as to her, because she has appeared and defended herself in court.
Yes, Your Honor.
All right, so I'm denying the motion to dismiss, denying without prejudice the motion for judgment by default, and then you need to proceed as instructed, okay?
Yes, Your Honor. May I ask a question, please?
All right.
Each individual, I was suing them as a group, and I still have to submit an individual default for each one?
Yes, there still needs to be a separate default entered against any defendant that you have served and hasn't timely responded.
Yes, but I'm not suing each one for $300,000. That was the group. So I can break
you can file, and I'm sorry, you need to get, if you get default entered against multiple different defendants, you can file together the application for default judgment against all of them and just show in there what your damages are that were caused by the different defendants. So in other words, you don't have to file a separate application for default judgment as to each of them, but you'll need to demonstrate damages as to each of them that you're seeking a judgment against.
Yes, ma'am.
Okay? All right. Thank you, sir. I appreciate your time today.
Thank you.
Okay, that's all.
Thanks, Judge. Thank you.